Welcome to meeting number 72 of the House of Commons Standing Committee on Justice and Human Rights pursuant to the order adopted in the House on March 22nd, 2023. The committee is meeting in public to continue its study of Bill S-224, an act to amend the Criminal Code. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd. Members are attending in person and remotely using the Zoom application. Before I go into that, I believe I have consent from everyone to, even though the bells are ringing, that we'll go till maybe 10 minutes before. So we'll get all the witnesses to speak for their 5 minutes time, and then we'll do the round of questions after the vote, if that's okay. All nods okay? Yes, good. Okay. Yes, Monsieur.
Il y a des témoins en ligne.
There are witnesses online. Were tests done with the interpreters?
They were okay?
They were okay, yes.
Merci, Monsieur le Président.
Thank you, Chair.
So those that are, a couple comments for the benefit of witnesses. Please wait until I recognize you by name before speaking. For those participating via video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. If somebody can turn the volume. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either English, floor, or French. For those in the room, you can use the earpiece and select the desired channel. For members in the room, if you wish to speak, please raise your hand. For those on Zoom, please use the raise hand function, and the clerk and I will do our best to accommodate you in the rightful order. So welcome everyone. We are studying Bill S-224, an act to amend the Criminal Code, trafficking in persons. For today's meeting, we have with us Don Way, barrister via video conference. And we have New Day Youth and Adult Services, Wendy G, Executive Director, also Zoom. And we have from Bridge North Women's Mentorship and Advocacy Society, Cassandra Diamond, Founder and Executive Director, in person. So maybe we'll go over to you, Ms. Diamond, for 5 minutes, and then I have little cue cards if you just pay attention when you're about 30 seconds away, and then when your time's out, so I don't have to interrupt you. Perfect. Over to you, Ms. Diamond.
Good afternoon, members. Thank you for inviting me to share with you today. It is a privilege to be here and have the opportunity to speak as the founder of Bridge North, but also as a survivor. I would like to share why I believe Bill S-224 would help trafficked persons. By combating trauma bonding, a known psychological impact that people who are trafficked experience as a result of traffickers' manipulative tactics. Under the proposed amendment, the requirement to prove a reasonable expectation of fear would be removed. When I was trafficked, I was not afraid all the time. But when I was, it was overwhelming horror. For example, I recall a time when I overheard my trafficker speaking to one of the girls on the phone, whom he sent out after a 13-plus hour shift to a so-called after-party. I could hear her in the background saying my trafficker's name. She was crying, she was sobbing, and she was begging for him to send somebody to come and get her out of there. There were approximately 8 to 9 men in that room. They were taking pictures, they were recording, and they were using her in the most violent of ways. They gang raped her, and she called him my boyfriend, my trafficker. You see, she was no longer afraid of my trafficker anymore. She saw him as someone who could offer help and that could keep her safe. It was lost on her that he was directly responsible for the unimaginable sexual violence she suffered at the hands of so many men that night. She called him to say, could you make them stop? And his answer was, it will be over soon. This woman didn't fear my trafficker or her trafficker anymore. She feared the customers who were doing all of those brutalizing things to her. This woman's story, though, is not unique. I have a similar story of my own, and so do the many that we serve today. This is why removing the requirement to prove reasonable fear from the definition of exploitation is so very important. Many girls I know that have gone to court have said that proving fear as currently required would hinder them from coming forward. In trauma bonding, we start to view the traffickers who facilitate violence as someone who is offering help, and this is proven over and over again. When many of the girls I know see their trafficker in court, they feel love towards their trafficker, and all of the feelings of fear have just gone out the window because of trauma bonding. S224 will support victims by reducing the burden they experience, testifying, and trying to prove that they feared their trafficker. The proposed criminal amendment would eliminate the difficult requirement the criminal code currently places on prosecutors to show that there was reasonable basis for the survivor to fear her safety. This would account for situations like mine, where my trafficker had manipulated me to see him as someone who offered safety and protection, rather than the one who facilitated brutal sexual violence against all those he trafficked, myself included. This bill will support victims in coming forward in the court process and reduce barriers, which will allow more victims to feel safe to share their allegations over time. S224 will allow us to assist persons who are trafficked in licensed systems, whether for sex, labor, or organs. Based on my knowledge and experience in the sex industry, girls are being exploited from region to region, municipality to municipality, in massage parlors and the like across the GTA. These women are forced to sell sexual services 6 to 7 days a week. Typically, there is one girl who monitors the phone that speaks more English than any of the other girls. She is tasked with supervising the other girls who are also being trafficked there. They all live together in the same house. They go most everywhere together, commuting together, eating together, as they have extremely limited other options. This tactic can be related to debt bondage, an all too common method traffickers use to reduce one's ability to leave. The girls in these situations are being controlled, directed, and coerced by third-party traffickers to engage in these brutally dangerous situations with men who purchase sex, while hiding behind the veneer of offering safety, security, and a licensing system that keeps them bonded to their traffickers. The proposed amendment will help people who are trafficked into Canada from another country, such as those who see their trafficker as someone helping them with language interpretation or helping provide for their basic needs like food and shelter. It will help people who are most vulnerable in society, who are being trafficked and were targeted due to their cognitive impairment, neurodivergence, or other impairments that impact their ability to understand and process fear. In summary, Bill S224 makes trafficking in persons easier to prove, as survivors will not have to prove their state of mind, which is inherently subjective. It provides survivors with fewer barriers to seek justice. It removes the tool of manipulation from the trafficker's arsenal, meaning that the trafficker cannot hide behind a carefully manufactured lie that he offers to safety to the women that he exploits, even if he succeeds in convincing his victims of that lie. Very importantly, it's trauma-informed and it's survivor-first legislation. Canada's trafficking survivors deserve better than what we currently have, and S224 is that better. Thank you for your time. I look forward to your questions.
Thank you, Ms. Diamond. We'll next go to Ms. Wave via video conference for 5 minutes. Your mic is muted, sir. Go ahead, Ms. Wade.
My apologies. Thank you for the invitation to address this honorable committee. In my practice, I exclusively represent complainants in criminal matters, almost always in the area of sexual assault or human trafficking. Human trafficking complainants are among the most vulnerable who engage in the criminal justice system. And I thank the committee for the attention to and concern for the vulnerable victims of human trafficking. I would support any amendment to the code that would assist my clients in their journey through the criminal process, and particularly amendments that would provide human trafficking victims with the same protections granted to victims of sexual assault, which is a notable gap in the present law. Since I was contacted by the committee last week, I've thought very carefully about the various impacts of the proposed legislative changes, but reluctantly, I must advise the committee that I cannot support the proposed amendment. I have two main reasons for taking this position. The first is that it is unnecessary, and the second is that the amendment would result in unintended delays and constitutional challenges that would be to the detriment of complainants. I say the amendment is unnecessary because it is based on a misapprehension of the law, at least as it stands in Ontario. It is not necessary for the Crown to prove that the complainant is fearful. The Sinclair case from the Ontario Court of Appeal indicated that actual fear on behalf of the complainant is not an element of the offense. My point here is that the stated reason for the amendment is to remove the fear component from 279.04, but that is unnecessary given the current law. Specifically, the Sinclair case lists a number of circumstances the court may consider in assessing whether the complainant objectively had a reason to fear, even if no fear is expressed by the complainant. Those circumstances are expansive and include, I quote, vulnerability due to age or personal circumstances such as social or economic disadvantage and victimization from other sources. And there are other considerations. In totality, these considerations listed in Sinclair appear to provide a broad range of circumstances the Crown can rely upon to satisfy the court that the complainant had an objective reason to fear, as opposed to proving a subjective fear. My second concern is about the constitutionality of the amendments. The bedrock of Canadian criminal law is that the Crown Attorney bears the burden of proving guilt beyond a reasonable doubt at all times. This burden must never shift. The presumption of innocence is of fundamental importance in the criminal justice system, as it serves to place the burden of proof squarely on the Crown. Let me pause here. I advocate for complainants. My job is to ensure that their rights are protected and that they receive all the benefits they are entitled to under law. But amendments that lead to time-consuming constitutional challenges do not benefit complainants. In fact, they have a detrimental impact on the criminal justice system as a whole. The proposed amendment would undoubtedly lead to constitutional challenges, and in such challenges, it is not uncommon to review parliamentary proceedings to decipher the intention of Parliament. The parliamentary record in this matter may well lead to the conclusion that the intention of Parliament was to shift the burden of proof to the defense, and therefore lead to a finding of unconstitutionality. As we know, it takes years for cases to wind through the system. Constitutional challenges are time-consuming and deflect energy and resources. There would be a ripple effect that would add to the delay that continues to plague criminal courts. And please bear in mind, the court system continues to struggle with the burden of COVID-related delays. Further, a finding of unconstitutionality may lead to numerous cases being thrown out. Again, I raise the issue of constitutionality of the proposed amendments from my perspective, gathered by years of experience representing hundreds of complainants in sexual assault and human trafficking cases. We know that the delay in getting a case to trial is tortuous for a complainant as they anxiously anticipate facing their abuser in court. My fear is that this amendment would introduce confusion in this area and be found to be unconstitutional. Thank you very much.
Thank you, Ms. Way. We'll next go to,
Chair, you can interrupt.
yes.
9 minutes left, and my app, I can't get it working, so I'm going to have to go to the House to vote.
Okay, so we will suspend, and Ms. G will listen to you just right when we return, which will probably be in about 20 to 25 minutes, if that's okay. And then we'll listen to you, and then we'll go for a round of questions. Are we okay with that? Yes. Thank you. Now resume our opening remarks. We'll begin by we'll conclude by Ms. G for 5 minutes.
I want to thank the Standing Committee members for the opportunity to speak today about Bill S-224, an act to amend the Criminal Code, Trafficking in Persons, to remove the unfair burden placed on exploited individuals who must prove that there was an element of fear in their abuse to obtain a conviction in court. My name is Wendy G., and I'm a mother of a daughter who was sex trafficked as a teenager here in Ottawa. In my professional life, I'm the executive director of a charitable organization that provides long-term restorative housing and programming for young women that have been sex trafficked throughout Canada. I also chair the Ottawa Coalition to End Human Trafficking, a steering committee of 40 plus frontline human trafficking organizations in Ottawa and the region. When young people come to a new day, they want to move forward and start their recovery. Many have spent months, if not years, living with sexual violence and physical abuse. The result is horrific trauma, PTSD, and addiction challenges. They have missed most of their formative adolescent lives that should consist of attending school, making friends, and learning life skills that prepare them for adulthood. Instead, they're forced into a life of sexual violence, 10 or more dates per day with strangers who have purchased them for their sexual fetishes, physical violence, beatings, and torture if they do not perform and make money for their traffickers. Amid this deranged lifestyle is a person, a trafficker, who controls every movement of that victim. This victim becomes dependent on their trafficker for everything from tampons and toothpaste to food and clothing. They develop a trauma bond where the victim now believes that the trafficker is their protector. They may fall in love with them and feel that the trafficker holds their best interest at heart, including keeping them safe. The victim is indoctrinated to believe that it's us against them mentality, meaning the trafficker and the victim are together against the rest of the world that wants to pull them apart. Is this logical reasoning? Of course not. But a trafficker knows his business, which is manipulation and coercion. A trafficker will use any tactics to keep money from their victim, making money from their victim, even if that means keeping their victim in love with them. So you can understand how challenging it is for a victim to come forward and provide a statement to the police. Even though their situation was horrific, the victims still had their basic needs met, and they found it challenging to believe they were being exploited. My daughter told me she loved her abuser. She only did what she did to help him because he had an addiction. She thought she was complicit and consented. Now she knows this is not true. She still has days that she struggles with what happened, and very rarely will she discuss it. And honestly, I can't blame her. The young people I work with say the same thing. They want to move on. They don't want to discuss it anymore because it hurts. They feel shame, they feel stupid, and they believe they consented to their situation. Throughout my tenure as the executive director of A New Day, only 2 young women came forward and provided a statement to law enforcement about their trafficking situation. It takes incredible strength to do so. They have to relive their sexual abuse, addiction, and violence, and the shame of a horrific lifestyle they were forced to endure. They know if they provide a statement, they will face their abuser in court, and all those repressed feelings will overwhelm them. They also know they will have to explain why they participated in a lifestyle that put them at risk, and why simply they didn't leave. Why should a victim have to explain why someone abused them? The burden of someone's violent, coercive behavior and control should not be placed on the victim who has suffered. I see firsthand what a trafficker's violent behavior leaves behind. Broken noses and bones that were not medically set back in place. Fertility issues because of botched abortions, multiple miscarriages, chronic STIs, not to mention the violence of repeated and daily, let's call them rapes, because that's what they are. Nightmares, trust issues, low self-esteem and self-worth, depression and anxiety, and self-harm in the form of cutting where wrists, arms, inner thighs, vaginas, and necks have been repeatedly slashed to release the mental pain they're enduring, or they can't do it anymore. They return to the life because they feel that's where they belong, overdosing on drugs and death. Eliminating the burden of proving they were fearful while they were exploited tells a victim that we believe them, that what they've endured was not a measure of their worth or value, was not indicative of the type of treatment they deserved, was not the result of poor decision-making, and that your victimization will not be continued by our justice system. Thank you.
Thank you, Ms. G. We'll now go to our first round of questions. We'll begin with Mr. Caputo for 6 minutes.
Thank you very much, Mr. Chair, and I want to thank all of our witnesses for being here. I have to say that I was very moved when I read all of your profiles that you provided. These are difficult things to read. I commend each of you for your bravery and your strength in dealing with something that really often flies under the radar. Ms. Way, I commend you as well for the work you've chosen to do. I've done some 278 hearings on the prosecutorial end, and they're very difficult to do. They're difficult to navigate because they're very complex. So I thank you for doing those. I'm not sure if anybody here wants to chime in, but something I think that goes unstated and that the general public doesn't understand is the insidious nature of this type of offending. It's almost as though people think it doesn't happen. And yet here the three of you are telling us not only does it happens quite regularly. Do any of you have anything you want to comment on that and just the need for reform in this area?
If I could address the committee.
Yes, go ahead.
Thank you. In my experience, in my practice, I generally represent complainants in sexual assault and human trafficking in 3 specific pretrial motions. And Mr. Caputo, thank you for mentioning 278s. That's one of them. An important thing to realize is that the protections that a victim of a sexual assault, a complainant in a sexual assault matter, the protections that she is afforded in the criminal code are not provided to human trafficking victims unless part of the charges on the indictment include a sexual assault. So I would ask the committee at some point to look at that question and ask yourselves if there is a way that those protections can be extended to victims of human trafficking. It would seem to me that the underlying basis, the underpinnings of why we have those sections that protect victims of sexual assault completely apply to the vulnerable victims of human trafficking. And at the moment in Ontario, we have a line of cases where courts have gone both ways on the question of whether those protections can be provided to human trafficking victims. But this is being litigated. The preponderance of decisions say yes, they should be entitled to those protections, but we also have a few cases that go the other way. So we need clarity in that area.
Suppose it would be as simple as looking at the application provision in Section 278, which I haven't looked at it admittedly in some time, but it would say something along the lines of when a person is charged with Section 271, something like that, or these offenses, that Section 278 is engaged. So I would imagine the amendment would be pretty straightforward, as just by including a couple of sections. In other words, just including the relevant sections. Would you agree with that?
Yes, yes, I do. Thank you.
Thank you. One thing, too, I was struck by was when talking about human trafficking, and this just doesn't get discussed a lot in society, and I can't remember who raised it, whether it was Miss Guy or Ms. Diamond, the role of pornography and how, you know, people are accessing these things. I assume it, well, I don't assume, I believe at a younger and younger age with the proliferation of the internet. And I would imagine that this has contributed, or based on the witness profiles, that there's been a contribution to what you're telling us here today. Can either one of you expand on that, please, if you feel comfortable?
I could, if the committee
Thank
would
you,
allow.
Ms. Diamond.
Pornography is used in a variety of ways to groom a victim, to find certain sexual practices acceptable. When you're viewing it on TV, traffickers are really just kind of really grooming you to find it acceptable. The same reason why they provide drugs during pornography as well, to reduce inhibitions. But we also know that pornography and the internet are used in every transaction where trafficking takes place, right? So, for example, I work with 12 to 17-year-olds. Any image taken of that child is automatically a child sexual abuse image, right? And therefore, once it's distributed, it becomes even another crime. And so we recognize that the role of pornography really does impact trafficked persons, especially when it comes to the consumership of them and the commercialization of their sale, right? Pornography proliferates women being depicted as a weaker member and only good for the hypersexualization of that person. So those are a few things in the role that pornography plays with trafficked persons.
Thank you. I'm out of time. Thank you again for all being here. Thank you, Ms. Diamond, for that.
Thank you, Mr. Caputo. We'll next go to Ms. Dillon for 6 minutes.
Thank you, Mr. Chair, and thank you to all of our witnesses for being here today, testifying about this very difficult issue. I'd like to start with you, Ms. Diamond. In your opinion, do all provinces use this same definition of exploitation? And do you see a difference between the Ontario and Quebec interpretation?
Let me say that I don't find equal downforce across Canada, which is problematic, but it's also problematic that it takes us out of place of being a global neighbor. So on top of, unequal downforce of the law in Canada, we also then are not contributing international members to the global problem of human trafficking.
Okay. And would any of our other witnesses like to add anything to that? Ms. Guy or Ms. Way?
I can indicate that we have at least some, sorry, I think I have a problem with my microphone. At least some Ontario courts, specifically there's a case, a Superior Court of Ontario case by the name of D'Souza that commented that our current definition, our current working model is actually advantageous over the international model. So I think that there is an alternative. I think that the legal framework that we have now actually works. I represent complainants. I want the situation to be easier for them. I am unhappy when my clients are ground through the system, but we have to tread very, very carefully in terms of any amendments and take a very close look at the way that the legislation and the case law hang together now. I don't know if the committee is planning to hear from the Ontario Human Trafficking Prosecution Team or the Nova Scotia human trafficking team, but I would think that those specialized prosecutors may well have an analysis of this law that would be very informative to the committee.
Thank you, Ms. Way. And maybe if I could follow up with you, we also know that the criminal code broadly interprets the human trafficking provisions to hold into account those who are trafficking and those who have also engaged in psychological forms of coercion. Can you please give us any ideas, and maybe this is for all the witnesses, but we'll start with Ms. Way. How could we ensure that prosecutors keep the tools that are currently in place if Section 224, it was to pass? Thank you.
Well, as I indicated, my concern is that these amendments would create, frankly, chaos within the prosecution sector in terms of how they would be able to deal with the cases that are in the system now and the effect of any constitutional challenges. So I think that it would be very problematic to try to have the amendments and then graft on top of them the law that we were already dealing with, because it may well conflict. So I think that would be a problematic way to proceed.
And Ms. Diamond, would you like to add anything to that?
I don't think at this time I would.
Perfect. I thank you so much. And maybe if any one of you can answer this question, why do you think human trafficking and the victimization of women, especially those of Indigenous origin, is underreported?
If I may, all sexual related offenses are underreported. So I think that it just falls with that umbrella. And of course, people who are marginalized are less likely to feel confident to approach the police for help, and are, quite often more likely to shirk away from the police. Sometimes, I shouldn't say often, but at least sometimes, my clients are both complainants in a criminal matter and also have their own, are in conflict with the law in and of themselves. So it can make it very difficult for victims of human trafficking to engage with the police and report. But I do think that it also falls into that under that greater umbrella of underreporting of sexual assaults.
I've also found, that we have found that when complaints come into police, they often will come in as domestics, not human trafficking. It looks like a couple is fighting. I was trafficked for a decade. I thought he was my boyfriend. And so persons are also in this situation. So they often are reported as a domestic, and of course, then the trafficker does their job and coerces that victim once again, manipulates them once again.
Thank you so much. I think I'm out of time.
Thank you, Ms. Dillon. We'll next go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, witnesses, Ms. Diamond and Ms. Way and Ms. G, for being here with us today. My questions for now will go to Ms. Way. In your preliminary remarks, you talked about the presumption of innocence. I would like to hear more about that. What are the problems you see when it comes to the presumption of innocence if we were to adopt this amendment in the Criminal Code?
Thank you for that question. I reviewed the third reading of this bill, and what jumped out at me was this sentence. This will put the onus on the perpetrator rather than the survivors. Now, there should not be an onus on the survivors, but there is an onus on the Crown. And I'm very concerned that a constitutional challenge to this bill on this record would lead to a finding by the court that this amendment is unconstitutional. And that would wreak havoc for all human trafficking prosecutions that are presently in the system, and might even affect ones that have been dealt with that are under appeal. So that's my concern, sir, that we have to tread very carefully. The Supreme Court of Canada, in cases like Mills, has said that trial fairness is seen through the eyes of the defendant in terms of their right to full answer in defense, and we would all be in agreement with that. That also courts should consider the interests of the complainant and the interests of society as a whole. And going back to my earlier comments, there are other things that could be done to assist human trafficking victims that would not give rise to a concern that this is unconstitutional because the onus has been shifted.
Merci, Madame Way, mais
Thank you, Ms. Way. Once again, if I take the current text of 279.04, paragraph 1, we retain what is being withdrawn is the requirement that evidence be provided. It's being read very fast for the interpreter, and I don't have the text before me. Is that the text that transfers the onus? The interpreter would like to say that it was read very fast.
parce que ça allège le fardeau de preuve de la couronne.
It alleges that the onus is on the crown. They don't have to prove that it was reasonable for the victim to expect the refusal to endanger their safety. The Crown prosecutor doesn't have to bear that onus. But what about the accused?
I'm a little bit challenged by your question, sir. What I understand from some of the other meetings that have been before the committee is that there was a suggestion that this amendment would mean that the complainant would not have to provide evidence in court on this issue. Now, there is nothing in the law that says that the complainant must give evidence. Of course, the Crown can rely on the best evidence that they have. But in this type of case, it is almost always needed that the complainant has to come forward and give evidence. That's even the case where human trafficking complainants don't want the prosecution to proceed. And as we've heard through all these meetings, very often the victims of the crime actually identify with their abusers. So if the goal is to protect complainants, to remove that onus from the Crown, I don't think that that's a legally sound way to proceed in this matter.
Merci. Et l'autre,
Thank you. Bill S-224. I'm trying to go fast. It talks about any other similar act. I imagine that you've read the bill. At the end, there's mention made of any other similar act. Don't you think that this is overbroad? Do you think this is a good addition? I'm left only with 30 seconds. You have the floor, Ms. Way.
Thank you. I would ask that the committee look at this Sinclair case from the Ontario Court of Appeal, which gives an exhausted list of circumstances that the court can look to in assessing whether the objective person would have found fear, not the subjective experience of the complainant.
mais à votre avis d'avocat,
Ben, in your opinion as a lawyer, but when we talk about any other similar acts, don't you think that is too broad? Do you think this comply with the regulations?
Very quickly.
I'm sorry, sir. I don't have a quick answer to that. My apologies.
Thank you, Monsieur Vertin. We're
Merci.
next go to Mr. Cannings, please, for 6 minutes.
Well, thank you, and I'll stay with Ms. Way.
I'm out of time already? No. It seems that one of the goals, perhaps not the main goal, but one of the goals of this S224, this amendment, is to make it easier to obtain convictions for trafficking offenses. And I'm just wondering if, Ms. Way, you could comment on whether that would be the case, and also what are the other factors that might be causing lower rates of convictions for this crime.
You've asked a very big question there, sir. Certainly, the criminal justice system is chronically underfunded. We are losing cases for 11B, which is when a court case takes too long to complete, and it's therefore stayed by the court. These human trafficking cases are very complex cases. One thing I have not heard discussed as of yet is that very often it's not one person who's charged with human trafficking, it will be several. And recently, I've had a number of cases where there have been 4 defendants, 4 people on that indictment. That makes them very complicated cases. It takes a long time for them to work their way through the system. So we need more resources in the court system. We need more courts, we need more judges, we need more crowns, we need more funding for legal services for complainants. So all of those things come to bear. I do not think that as a society we can touch the presumption of innocence and the burden that's on the Crown now. That is what makes Canadian criminal law so fair to all of us, even when it leads to more wrongful acquittals than wrongful convictions, but it protects us all. So my concern is that the proposed amendment would be ultimately found to be unconstitutional, would cause more problems in the system, would result in more cases not being brought to justice.
Mentioned that often there's more than one person on that charge. Do you think that if we broaden this definition by taking away the question of fear, that there's a danger of, capturing people that are perhaps not really in the trafficking business into these cases of trafficking, and that might be one of the unintended consequences? Is that something you're concerned about?
So I'm just here. I think that what you may be referring to is the possibility of someone who drives the sex worker somewhere, that person, somebody who's affiliated but is not actually exploiting the complainant, that person may be caught up. Is that what your question is?
Yeah, that's more or less it. There could be a number of different tasks these people have.
Yes. I don't really think that is something, I don't instinctively go to that particular concern. Sex work is not, in and of itself, is not illegal in Canada. I have represented sex workers who are completely self-employed, declare their income, and are independent business people. That's not criminal. So I don't really think that this amendment would lead to that problem. But I also, as I've repeatedly said, I don't think that the amendment is necessary. And I don't think that the Crown now has to prove that the complainant was fearful. They have to prove there was objectively that they could have been fearful.
And how much time do we have?
1 minute.
1 minute. Okay, well, just continue going back to the business of resources. Is it investigative resources that need to be strengthened in terms of policing, things like that, or where do we need those extra resources to ensure that we can deal with these cases properly?
I'm quite sure that any justice participant who comes before the committee will say that their particular sector needs more resources. What I can say, the City of Toronto has a new courthouse, Ontario Court of Justice, and every day a number of those courts are unable to open because of a lack of staffing. So at the very baseline, we cannot open courts, all the courts that are available or should be available, and we cannot run all those cases. That in turn has a ripple effect that everything that gets delayed gets pushed down the road. So when you're asked about resources, it starts from the very most basic level of the system.
Thank you.
Thank you, Mr. Cannings. I want to thank all the witnesses for attending. Thank you, Ms. Diamond and Ms. Way and Ms. G. Ms. G, you had your hand up. I'm wondering if you had a point to make before we end this.
I did. One thing that I wanted to clear up that Ms. Way said, she was talking about a sex worker and a driver. When a youth is being trafficked, they're not a sex worker, and you know this, under the age of 18, and usually the drivers are complicit, and they're part of what's going on in a coercive situation. So that is a completely different conversation. I think one of the challenges that I'm hearing here right now is that we're talking about funding for court systems, where we should be talking about victims, advocacy, and we should be talking about prevention and education in our schools for our parents and caregivers. And that's completely not even being discussed. I understand that the court system is overburdened, and I don't know how to answer that because that's not my lane of work. My lane of work are these young women and young men that have been exploited since they were children. And I think that's where our focus needs to be. And if we're going to amend a law that is going to help support them come forward and provide a statement where they don't have the burden of proving that they were scared the entire time, then that's something that we need to consider.
Thank you.
Because I'll be quite frank with you, I don't care about the traffickers' rights.
Thank you, Ms. G. I want to thank all three witnesses and thank you for the time and apologize for the interruptions we had because of votes, and we thank you for your patience. So I will conclude that part. I just have some quick I guess Mr. Moore has left, but we got a letter from FINA, from the Finance Committee, and just wanting to know if we wanted to study any of the pre-budget consultations for the fall. We have to let them know by the end of, by July 31st. So I guess they want to offset some of their burden and doing it, any justice-related ones. So if you can let me know, and I will answer the letter accordingly based on the feedback I get from the vice chairs as well as other members. So, yes, please hold on. Let me put my...
Sur cette question.
On that question, Chair, I think it would be a good idea to contribute, but I do not think that our committee should use up its time we have in advance in the fall. I suggest that we look at our priorities and our order of work when we return in September and not now. It's going to be too soon. We don't yet know what we're going to be studying in September.
Thank you, Monsieur Fortin. Unfortunately, Mr. Moore is not here, so I'll just get his feedback too. But I think I'm of the same inkling of not doing that. I think we have a lot of studies to do, and we'll get overburdened with those. And some of those will come our way anyways, if they're legislation. So I'm inclined to say the same. I'll also speak to Mr. Garrison when I get a chance as well. And then I'll conclude it with all of you before. Thank you. Meeting's now adjourned.